ICSI IIT, that is final word on IBC. We have with us two faculties, Shweta Bharti ma'am and Mr. S Badri Narayanan. We shall discuss three Supreme Court cases today. The first session will be taken by Shweta Bharti ma'am on Kotak Mahindra Bank Limited versus Key Precision Parts Private Limited and others. You may post your queries in the chat box and ma'am will take them at the end of the session. Let me briefly provide you introduction of Shweta Bharti ma'am. Ms. Shweta Bharti carries with her an enriched experience of almost 20 years as litigator, having argued the matters herself in almost all high courts of the country besides the Honorable Supreme Court of India, Competition Commission of India, NCLTs, NCLATs, and have led some path-breaking cases including reverse insolvency. She has also represented her clients before the international
Sorry, Anu, just go ahead.
1 second. She has also represented her clients before the international and domestic arbitral institutions, viz. ICC, SIAC, LCIA, etc. Ma'am has expertise in dispute resolution, arbitration, as well as insolvency and bankruptcy, real estate, environmental laws, corporate governance, and compliance. She is a recipient of several awards and is also a speaker at various forums, seminars, and webinars, both domestic as well as international. Ma'am, you may now start the session.
Thank you. Thank you so much, Anu, for this elaborate introduction. So, hi, good afternoon, everyone. And our apologies for starting a little late, but then, better late than never. The issue that we are going to talk about is a very interesting one. I mean, this is an issue where we have been going back and forth with the judicial precedents right from NCLT in 2017, and thereafter there are a plethora of judgments going back and forth on whether the Limitation Act will be applicable in cases of IBC. If it will be applicable, then to what extent, when does the limitation get triggered in IBC cases? And also an understanding with respect to the terms like, acknowledgement of debt. So acknowledgement of debt means what? Would an acknowledgement in a balance sheet would amount to a sufficient acknowledgement? And also whether the debt, the definition of when is the debt payable. So the due and payable debt, when does it get triggered? And whether an one-time settlement, which is entered into after the time limit for initiating CIRP is over, whether that can be taken into consideration for triggering the Limitation Act. So I think these are few questions which have been going, around in circles for some time now, and therefore I have prepared a short PPT because it always helps to understand issues when we are talking in PPT terms. So just give an understanding of, what the judgments, how it has evolved over a period of time. So if we look at the judgment before Kotak Mahindra Bank, that is more relevant because we will be able to understand what exactly, how it has evolved. So let's look at the first judgment in this case, which is the case of Neelkant Township and Construction. So this case of Neelkant Township and Construction versus Urban Infrastructure Trustees. This judgment is of the NCLAT. And in this judgment, in fact, the discussion that was held was with respect to where the NCLAT had taken a view that the ground taken on behalf of the appellant, that the debt is barred by limitation, as the debentures had matured between the years 2011 to 2013, is not based on a substantial law, and there is nothing on record that Limitation Act will be applicable to IBC. So this was one of the first cases where the issue of limitation had been tested. In fact, there have been, in fact, judgments during these times where there were findings given by the Honorable NCLT, NCLAT, as well as up to Supreme Court in some of the cases, which we will discuss, some of them that we will discuss, and some, because there are so many of them, have not taken all of them. But where they had also taken this issue that whether, Limitation Act should apply to IBC at all or not. That was the first test, whereafter, in fact, there was an amendment which was brought in the IBC itself in order to include this issue. And then if it is applicable, then to what extent? So the first judgment in this regard to test was that whether the Limitation Act is applicable to IBC in the case of Neelkant Township. And the NCLAT had held that the Limitation Act will not be applicable to IBC. Then in the second judgment of 11th of October 2018, so from 11th August 2017 to 11th October 2018, this is a Supreme Court judgment where the Supreme Court in BK Educational Services versus Parag Gupta had held that Article 137 of the Limitation Act bars an IBC application for a default which is older than 3 years. So the reliance was placed in this case on the residuary provisions of the Limitation Act, and where it was held that if the action has been initiated after the 3 years of the claim having become due and payable, in that case, Article 137 would come into play, and there will be the bar in terms of initiation of the IBC proceedings. Now, if you look at Section 5 of the Limitation Act, it also provides that it provides for condonation of delay. So the Supreme Court did go into that aspect as well, that there can be a condonation of delay, but that will be depending on the peculiar facts and circumstances of that case and will apply to proceedings under IBC as well. So now here there was a shift that was made with respect to applicability of the Limitation Act, which will be applicable even for proceedings under IBC. Then the next judgment in the case of Gaurav Hargovind Bhai Dave versus Arcel, here it was held that the period of limitation for the enforcement of a mortgage deal will not be applicable to applications which were filed under the provisions of IBC, and therefore they had made, in fact, Article 62 of the Limitation Act inapplicable to cases under IBC. Now, if you look at the next judgment, the set of judgments which have been discussed, and this is where onwards I would want to discuss the judgments a little bit in detail. And what I have done is I have provided for a detailed understanding of these facts. So the first judgment that we are going to talk about is Babulal Gurjar's case. So in this case, Babulal versus Veer Gurjar Aluminium Industries, what had happened is that this is a judgment of 14th of August 2020. So we saw the evolution before that. In 2017, what was the stand? 2018, what was the stand? 2019, what was the stand? Now comes 2020. So after, about 4 years of the IBC coming into picture, in this case, let me just discuss the facts of the case also a little bit. That JM Financial Assets Reconstruction Company, which was the financial creditor, had filed an application under Section 7 of the code before the NCLT for seeking initiation of the CIRP in respect of this company called Veer Gurjar Aluminium Industries Limited, which was the corporate debtor here. Now, in this case, the corporate debtor had defaulted on July 2011. So the admission was contested as it was filed in March 2018, and therefore it should be barred by limitation. In fact, the date of declaration of the NPA was also in 2011. That was taken as a default, and any acknowledgement under Section 18 of the Limitation Act also could not be proved by the financial creditors. Now, the interesting part here only was that the OTS in this case had come around 2018, which was also after 3 years of the limitation period. So when the proceedings were going on before the adjudicating authority and the appellate authority, the NCLT had accepted the application under Section 7 of the IB Code, and because of which the appellant moved to the NCLAT. The admission was contested against the appellate before the appellate tribunal, and in fact, the whole issue was with respect to, and the NCLAT also in fact held that this entire claim is actually barred by limitation, and therefore it cannot be entertained. My apologies, sorry. NCLAT had in fact held the reverse. NCLAT had upheld the initiation of CIRP against the corporate debtor under Section 7, stating that this is barred by limitation. However, the limitation with respect to mortgage was 12 years, and therefore the financial creditors had mentioned that the IBC, which came into 2016, if the claim has been filed in 2018, it is well within the limitation because it is only 2 years that the act has come into place. So that was the issue here. So on that, what Supreme Court had done, that the Supreme Court in this case emphasized on the preamble of the code, saying that the principal goal was to maximize the asset value and the balance of the stakeholders' interests. So the Supreme Court had used the case law to find that the corporate debtor's interest must be respected and that the liquidation was a last resort. And therefore, the court had held that it is not a money recovery method and it should not be used in that manner. So the Supreme Court underlined the applicability of the limitation period for a Section 7, which was 3 years from the date of default, unless the delay can be permitted. So the Honorable Supreme Court in this case had held that Article 62 of the Limitation Act does not apply, and the court is not for the enforcement of mortgage liability, and the 12-year limitation period for mortgage properties do not apply for Section 7. And this whole, the effort was against the intention of the code. So the Supreme Court had said that the limitation is basically a mixed question of law and facts. I think this is a stand that Supreme Court has taken in various other judgments as well. And therefore, the supporting facts are very necessary in order to understand the extent of the deadline. And the deadline cannot be extended with an acknowledgement or by setting a new default date. Now, this was something which subsequently, if we look at the other judgments, there has been a complete shift with respect to this view by the Honorable Supreme Court itself. So the Supreme Court in this case had held that the intention of the court is not to give a new lease of life to debts which are already time barred. And in this regard, they had referred to the judgments that we discussed of BK Educational Services versus Paras Gupta, and also of the Gaurav Hargovind Bhai Dave versus Arcel. There was another judgment that was also referred to by Supreme Court, which was Jignesh Shah versus Union of India, which was 2019 Supreme Court. So the bench would dismiss the financial creditors' arguments that the application is within limitation because the corporate debtor has constantly admitted its liability till 2017. And the bench ruled that Section 18 of the Limitation Act's debt acknowledgement rules do not apply to Section 7 of the IBC. The bench then ruled, while accepting that in the appeal, that even if Section 18 is relevant, it does not assist the financial creditor in the current case because the application did not suggest any debt acknowledgement. And therefore, Section 18 was only relevant for recovery suits and was not applicable for initiation of CIRP. So in this case, the verdict that was given by Supreme Court was that the case was time barred, and because the financial creditors couldn't prove an acceptance of obligation for a new date of default, the impugned decisions were vacated and the financial creditors' motion was denied. The court had in fact ruled that the moratorium which has been lifted and that the DRT or any other court tribunal could hear the cases without affecting the ongoing process. So this judgment was passed on 14th of August 2020. On 17th of August 2020, the central government notified the IBC Second Amendment of 2018 and introduced Section 238A into the IBC. Now, Section 238A was inserted into the IBC with the intention to basically make applicable the provisions of the Limitation Act to the proceedings under the IBC. In fact, the whole intention of Section 238A was to ensure that IBC is not used to give time-barred debts a second lease of life. So that was the whole, understanding. But because of the procedural and clarificatory nature of the section, the courts had held that the section would have a retrospective application. Now, the second, in fact, before we go to the second judgment, let's look at what does the provision of Section 18 of the Limitation Act say. So Section 18 of the Limitation Act provides for, and this is important because we are going to discuss Section 18 repeatedly. So there are two sections that we are going to discuss repeatedly until we reach up to the judgment that we are going to talk about, which is Kotak Mahindra Bank versus Q. So Section 18 of the Limitation Act provides for effect of acknowledgement in writing. So where before the expiration of the prescribed period for a suit of application in respect of any property or right, an acknowledgement of liability in respect of such property or right has been made in writing, signed by the party against whom such property or right is claimed, or by any person through whom he derives his title or liability, a fresh period of limitation shall be computed from the time when the acknowledgement was so signed. So the important aspect here is before the expiration of the prescribed period, an acknowledgement of liability which has been signed or written and signed by the party against whom such claim is being made, and in that case, a fresh period of limitation shall be computed from the time when the acknowledgement was so signed. So this is what section 18 talks about. Now, if you look at section 25(3) of the Contract Act, what does it say? It is a promise. So a one-time settlement is also a promise. It is a promise made in writing and signed by the persons to be charged therewith or by his agent, generally or specially authorized in that behalf, to pay wholly or in part a debt of which the creditor might have enforced payment, but for the law for the limitation of suits. So in any of these cases, such an agreement is a contract. And then there are explanations also given that nothing in this section shall affect the validity as between the donor and donee of any gift actually made, which is of course not relevant here. An agreement to which consent of the promisor is freely given is not void merely because the consideration is inadequate. So neither of the explanation actually goes requires any consideration. For us, what is relevant is section 25(3) in general, where there is a promise which has been made in writing, signed by the person to be charged therewith, and to pay wholly or in part a debt of which the creditor might have enforced payment, but for the law of limitation of suits. So this is the provision so far as section 25(3) is concerned. Now, in this background and context, if we look at the next judgment that we are going to talk about, this is Arsil versus Bishal Jaiswal. This is another Supreme Court judgment. And this Supreme Court judgment was, in fact, it was passed, I think, in April of 2021. And the facts of the case here is that this company called Corporate Power Limited had availed credit facilities from a consortium of lenders, but had defaulted on its payment obligations. So the lenders issued loan recall notices in 2015 and subsequently had assigned their credit facilities in favor of Asset Reconstruction Company Limited, ARCIL. So when the proceedings went before the NCLT Kolkata, ARCIL had filed a Section 7 application. And for CIRP against the corporate debtor disputed the Section 7 application's admissibility before the NCLT Kolkata on the ground that it was time-barred. So the NCLT Kolkata had concluded that the corporate debtor acknowledged the debt in its 2017 balance sheet, renewing the limitation term, and hence Section 7 of the application filed in 2018 was within the limitation period. Now the matter goes to NCLAT. NCLAT considers a few points. The first point which was considered was that NCLT Kolkata had concluded that the corporate debtor had acknowledged the debt in 2017 was fine. But then the entries in a balance sheet are acknowledgements of debts under Section 18. Balance sheets contain an admission of liability, and agents of the company who make and sign the balance sheet, they intend to make those admissions. So it is not inadvertently. You cannot take the plea that you did not have a knowledge of it. You have made the entry knowing that entry to be correct. And as the agent of the company who have signed the balance sheet, they have intended to make those admissions. Thus, the balance sheets do not cease to be an acknowledgement of liability merely because such acknowledgements arise from a statutory obligation. So in Babulal case, the NCLAT had noted the Supreme Court's observation that limitation is a mixed question of law and fact. When a party seeks application of any particular provision for extension of the limitation, the relevant facts must be not only be pleaded, but also the requisite evidence must be adduced. So as in Babulal's case, the Supreme Court had noted that the creditor did not allege the borrower the admission of debt and declined to apply Section 18 to him. The NCLAT had ruled the Supreme Court's remarks cannot be interpreted as a general principle that Section 18 is inapplicable to IBC. So then what did the Supreme Court do in this? Supreme Court in fact held that the applicability of the Section 18 of the Limitation Act applies to IBC, and that Section 238A of the IBC applies Limitation Act to NCLAT and the NCLT procedures as well. So the court ruled that Section 18 of the Limitation Act can be applied to IBC, and to support this decision, the court cited the Lakshmipat Surana versus Union of India judgment, which we will talk about now. and also the Seshnath Singh versus Baidyavati Shorapuli Cooperative Bank Limited. In fact, in the Seshnath Singh also, the Supreme Court had tested the applicability of Limitation Act, especially Section 18 of the Limitation Act, to the IBC provisions. And then Supreme Court in this case, in the Bikash Jaiswal case, held that the acknowledgement of debt under Section 18, and if it is to be decided upon the issues at hand, the Supreme Court relied upon the judgments, as I mentioned, Mahabir Cold Storage versus CIT, Jignesh Shah versus Union of India, A.V. Murthy versus B.S. Nagaswana. And then the Supreme Court stated that the minority judgment in V. Padma Kumar had raised the accurate contention, and thus the court had set aside the majority judgment. The court also went into the aspect of intention of acknowledgement. The Supreme Court ruled that intention is irrelevant in debt acknowledgement as long as there is a dual relationship which can be established between the creditor and the debtor. So the Supreme Court then spoke about also the function and the purpose of the balance sheets, and the court acknowledged that the preparation of the financial statement, including that of the balance sheet or in fact also the director's report, this was a statutory duty of the agents of the company under Section 92, Section 128, Section 129, 132, 134, and 137 of the Companies Act, and held that this did not preclude the balance sheet from acting as an acknowledgement. In fact, that is what is the highlight of this judgment, that the balance sheet can be taken as an acknowledgement of the debt. So the Supreme Court held that simply because the balance sheet is prepared by the corporate debtor under a statutory duty under the Companies Act, the opposing party creditor cannot be precluded from relying on the entry thereto as an acknowledgement for the purposes of Section 18 of the Limitation Act. In fact, it was held that there is a compulsion in law to prepare a balance sheet, but no compulsion to make any particular admission. So the admission is being made voluntarily. The admission is being made depending on the facts of the case. And it is the prerogative of the directors of the company and the agents of the company to decide on whether they want to make that entry in the balance sheet or not with respect to any creditor. And once that entry has been made in unequivocal terms, then it acts, against the company. Then the company is bound by the terms and conditions thereof. The court, in fact, explained that while the statute requires a balance sheet, no particular entry is required. And therefore, the Supreme Court turned aside the judgment of Bishal Jaiswal in this, passed by the NCLAT. Now, the third judgment that we are going to talk about is the judgment of Lakshmipad Surana versus Union of India. This was passed in March of 2021. And in this case, the interesting part was that the Union Bank of India was the financial creditor here, and they had extended the credit facilities to Mahavir Construction, which was a proprietary firm belonging to one Mr. Lakshmipad Surana, through two loan agreements, which was entered into in the years 2007 and 2008 for term loans of about 9 odd crores in one case, and I think about 2.5 crores in the second one. And this loan account was declared to be NPA on 30th January 2010. So the financial creditor had issued a recall notice in 2010 itself to the principal borrower. Now, the financial creditor then filed an application under Section 19 of the Recovery of Debts to Bank and Financial Institution Act against the principal borrower before the Debt Recovery Tribunal at Kolkata. The bank also, in fact, wrote to the corporate guarantor and the debtor in 2018 in the form of a purported notice of payment under the IBC, and the corporate guarantor and debtor replied to the notice of demand via the letter in December only, clarifying that it was not the principal borrower nor owed any financial debt to the bank and had not committed any default in repayment of the outstanding amount. So in this kind of a circumstance, the respondent filed the application under Section 7 of the Code against the corporate debtor before the NCLT Kolkata. The corporate debtor opposed the application. First, that principal borrower was not a corporate person. This ground was rejected by the adjudicating authority by its judgment of 6th of December 2019 and held that the application under Section 7 of the code had been initiated against the corporate debtor as it was coextensively liable to repay the principal borrower's debt as a guarantor. And upon failing to do so, despite the recall notices, the corporate debtor became liable to be proceeded against under Section 7. So then the appellant then appealed this issue before the NCLAT, which denied the appeal and confirmed the decision which was passed by the adjudicating authority. So it was in this situation that the matter was taken up before the Supreme Court. So the Supreme Court then held, and the Supreme Court had this first issue, which was before the Supreme Court, was whether an action under Section 7 of the IBC can be initiated by the financial creditor against a corporate person being a corporate debtor concerning the guarantee offered by it in respect of a loan account of the principal borrower which had committed default and is not a corporate person. So if the principal borrower is not a corporate person and the guarantor instead is a corporate person, can the guarantee be enforced against such a corporate person, or a Section 7 be filed against such a guarantor? Because the principal borrower is not a corporate person or a jural person. It was a sole proprietorship. So the Supreme Court had noted the insolvency rules for firms and or people under the Part 3 of the IBC, which was not yet notified by them. So the corporate debtor can be a company that borrowed the money, but the Supreme Court also took into consideration the fact that corporate debtor can also be a company that guaranteed another company or entity's loans. But then the IBC cannot apply to a non-corporate entity's debts is correct. So the Supreme Court emphasized that Section 7 of the IBC allows a financial creditor to begin insolvency proceedings against a corporate debtor and ruled that a corporate person becomes a corporate debtor when it guarantees repayment in case of the principal borrower or debtor's defaults. So the corporate debtor can be the main borrower, and Section 128 of the Contract Act, which provides for the liability of the guarantor to be coextensive with that of the principal borrower, that came into play with respect to the interpretation of the issue, that even though the principal borrower is a sole proprietorship, but because the guarantor is a corporate person, the Section 7 proceedings can be initiated against the corporate guarantor as the corporate debtor. And in the event of default, the guarantor becomes a debtor under Section 3, subsection 8 of the IBC. And so the Supreme Court had ruled that the principal borrower need not be a corporate person for insolvency proceedings to be commenced if it's a guarantor, which is a corporate person. Then the second issue that was also tested was whether an application under Section 7 of the IBC filed after 3 years from the date of declaration of the loan as an NPA, being the date of default, is not barred by limitation. So on this issue, the Supreme Court upheld the view which was taken by the NCLT and the NCLAT in their respective orders and affirmed the decision of NCLAT that a fresh period of limitation is required to be computed from the date of acknowledgement of the debt by the principal borrower, and in the particular the corporate debtor, which was the guarantor, which was done in 2018. So Supreme Court held that the application under Section 7 of the IBC was within limitation. So with these judgments in the background, there was the latest judgment which was discussed by the Supreme Court in the case of State Bank of India versus Krishi Dhan Seeds Private Limited. Now this judgment is of April of 2022. This judgment in fact just precedes the Kotak Mahindra judgment. And in this case, the NCLT had rejected the application which was filed by the State Bank of India, which was the appellant under Section 7 of the IBC against the corporate debtor, which had initiated the CIRP process. So the respondent had received the credit facilities from the appellant, and according to the appellant, SBI, the outstanding amount under the credit facility had totaled to rupees 102.4 crores. So in place of these credit facilities, the respondent along with the other persons had provided securities in favor of the SBI. Now, though the respondent, which is the Krishi Dhan, they had failed to honor the terms of the credit facilities, and in fact, they defaulted on the repayments. Hence, the respondent's account with the SBI was classified as a NPA. But when was it classified as an NPA was very relevant. That was in 2014. So SBI initiated the proceedings under SARFAESI as well as the recovery of debts due to banks and financial institutions under Section 93, while continuing to engage in negotiations with this Kishidhan. Thereafter, a letter was issued by this Kishidhan to SBI in 2016, where they had offered a one-time settlement. So we are looking at 3 dates: the NPA happening in 2014, then the initiation of the SARFAESI proceedings by the SBI in between, and then 2016, there was a letter which was given as a one-time settlement by the respondent Kishidhan to SBI. And that one-time settlement was conditionally accepted by the SBI. Thereafter, Kishidhan, in fact, unilaterally also tried to revise the one-time settlement to a certain lesser amount, which was refused by SBI. So in this kind of a situation, SBI initiated proceedings against Kishidhan under Section 7 before NCLT in September 2018, which was rejected by NCLT on the ground of limitation, because NCLT observed that Kishidhan's loan account was declared to be an NPA in 2014 itself, while the proceedings under section were initiated in 2018. So it was already barred, beyond 3 years from the date on which the right to apply had accrued. So this matter was challenged before NCLAT. NCLAT relied upon the decision of V. Padma Kumar versus Stressed Assets Stabilization Fund and other, and held that a statement contained in the balance sheet cannot be treated as an acknowledgement of debt under Section 18, and the proposal of one-time settlement, which was submitted by Kishidhan on September 2017, was also beyond the 3 years from the date of default. So in this circumstance, the Supreme Court had held that the acknowledgement in a balance sheet without a qualification can be relied upon for the purpose of proceedings under the IBC to take into consideration the aspect of default. Supreme Court, in fact, also had held that unqualified acknowledgement of debt in corporate debtors' balance sheet within a period of 3 years from the original date of default extends limitation for filing CIRP under Section 7 of IBC, as the Section 238A of IBC makes Section 18 of Limitation Act applicable to proceedings under IBC. And therefore, the Supreme Court held that the provisions of Section 18 of the Limitation Act are not alien to and are applicable to the proceedings under the IBC. And that an acknowledgement in a balance sheet without a qualification can furnish a legitimate basis for determining as to whether the period of limitation would stand extended, or so long as the acknowledgement was within a period of 3 years from the original date of default. And thus Supreme Court allowed the appeal and set aside the judgment which was passed by the NCLAT. So these were some of the judgments which had come prior to the Kotak Mahindra versus Q Precision Parts Private Limited. Now, what happened in this judgment of Kotak Mahindra? What was different in Kotak Mahindra judgment, which was not already discussed in all of these judgments that we spoke about just now? So in the Supreme Court, in the latest judgment, this judgment has been passed on 5th of August 2022. Here it was held that an application to initiate the CIRP against a corporate debtor is maintainable in respect of a time-barred debt if the debtor has, after the expiry of the limitation, agreed to repay the same. So that is where the whole differentiation is. Earlier, we were talking about the balance sheet and one-time settlement, but here, after the expiry of the limitation, also if the debtor has agreed to repay the loan, then in that case, the limitation period gets extended and begins from the date of admission. So the facts of the case are important here because Q Precision, which was the corporate debtor, it had availed various credit facilities from Kotak Mahindra between 2012 to 2014. So Q defaulted in repaying the dues, and thus in 2015, the account was declared as NPA. In fact, Kotak Mahindra thereafter recalled the entire debt and initiated the recovery proceedings under, again, Recovery of Debts and Bankruptcy Act of 1993. And also, in fact, they had taken steps under SARFAESI. Here in this case also, Q in fact proposed a one-time settlement, which was accepted by Kotak Mahindra, and the parties had signed a settlement agreement in 2018. So while the NPA was declared in 2015, the OTS was signed in the year 2018. But subsequently, Q did not adhere to the terms of settlement, and therefore Kotak Mahindra had to file an application under Section 7 before NCLT Delhi to initiate the CIRP against the debtor. The difference that was taken by Q was that the application was filed in January 2019, although the NPA had occurred in 2015, And therefore, the initiation of any action in 2019 after 4 years of the account having been classified as NPA would be barred by limitation. So the NCLT had rejected the contention by holding that the corporate debtor, by giving a settlement proposal, had admitted its debt, and hence the cause of action was a continuing one, which is the right understanding that the NCLT had derived. The application was admitted by NCLT and the CIRP was commenced against the corporate debtor. Now there was an appeal which was filed. And the appeal that was filed before NCLAT, the NCLAT had, by its judgment of January 2020, reversed the order of NCLT. And the basis for reversing the decision of NCLT was that on the one-time settlement proposal, which was given by the corporate debtor, that settlement offer was also given after the expiry of a period of limitation. So if you recollect section 18, it talks about the acknowledgement of debt also to be coming within the period of limitation. So if the acknowledgement of debt or the one-time settlement has been given after the expiry of period of limitation, in that case, it does not amount to acknowledgement of debt in terms of section 18 of the Limitation Act. So that was the finding that was given by NCLAT. And so as to the NCLAT had held that to extend the period of limitation, an acknowledgement must be with respect to a subsisting debt and must be given prior to the expiry of the limitation period. Now, the Supreme Court, when the appeal was filed before the Supreme Court, it considered the provisions of Section 18 of the Limitation Act, as well as Section 25, subsection 3 of the Contract Act, which we read earlier. And the Supreme Court held that even though the debt was barred by limitation, the same cannot be revived by the one-time settlement proposal, and the terms of settlement signed by financial creditor and corporate debtor constituted an agreement to pay a time-barred debt. Now, because there was an agreement which was signed between the parties, irrespective of whether the debt had become time-barred, the contract or the one-time settlement was enforceable contract under Section 25(3) of the Indian Contract Act. And so the Supreme Court, in fact, in this case had held that under Section 20, because of Section 25(3) of the Contract Act, the terms of settlement between the parties had become enforceable within 3 years from the due date of payment, which is provided for in the OTS itself. And since the due date under the terms of the OTS was 2018 onwards, December 2018 onwards, the application which was filed in January 2019 was within the period of 3 years limitation. So interestingly, the Supreme Court, in fact, held in this case, examined the certain clauses also. And those clauses are important because both the promise and the acknowledgement, which were signed by the parties, have an effect of creating a fresh limitation period. So the court held, in fact, provided for a very clear distinction between 25(3) of the Contract Act and Section 18 of the Limitation Act. Acknowledgement under Section 18 has to be made within the limitation period, and it need not be accompanied by any promise to pay if there is a dual relationship which is established. But under Section 25(3) of the contract, it gets attracted when there is an express promise to pay the debt that is time barred. So that promise would be a clear and unconditional one. That is the only precondition. So the application which was filed under Section 7 of the IBC would only fall under the residuary Article 137 of the limitation, and hence limitation period for such application under Section 7 or 9 is 3 years from the date of default. So this is what was the finding that was given by the Supreme Court in this matter. So the Supreme Court held that while the acknowledgement must be within the period of limitation and need not be accompanied by a promise to repay, however, the promise to pay in terms of the settlement agreement, that becomes the key and must be a promise to repay a time-barred debt and must be given after the expiry of limitation period, in which case the limitation period gets extended for a further period of 3 years from the date of promise of payment by the corporate debtor. So in applications relating to the initiation of CIRP, the tribunals and courts have consistently held that the acknowledgement of debt within the limitation period will create a fresh limitation period, basis which the applications were admitted. So in this case, the Supreme Court had applied Section 25 of the Contract Act and held that an agreement to pay a time-barred debt creates a valid and enforceable debt, the default in payment of which can form the basis for admitting the application and initiating the CIRP. So this is the present view of the Supreme Court, and which according to my humble understanding is the correct view of Supreme Court. Because while NCLAT had decided on the issue with respect to Section 18 of the Limitation Act, and to that extent, NCLAT was correct. But what NCLAT had missed in terms of the interpretation was the applicability of Section 25 of the Contract Act. And that is where Supreme Court had corrected the view of the NCLAT to say that if there is a fresh admission by way of the parties entering into a one-time settlement, whereby there is a separate provision for the payment obligations made, then the timeline gets triggered from the date on which that one-time settlement has been made, and the payment becomes due and payable as per the one-time settlement. So that is where I will end my presentation. Now, if there is, this is one very important aspect that I thought I'll, highlight. And this is something which was observed by the Supreme Court here. It said that the statute must be, read as a whole. And in fact, the court referred to a number of IBC provisions to outline the statute's structure, and that IBC was not opposed to the interest of the corporate debtor. Rather, the aim is to resuscitate the corporate debtor by enabling it to better its financial situation while also paying back the creditor's debts. In fact, it also defends the right of its workers and creditors. And in fact, it noted that in the order to interpret the IBC clause, the entire statute must be read. And then the relevant variables also has to be considered when we are interpreting the provisions, including the previous state of the law and the overall reach and application of the act and the harm that it was meant to address in terms of the statute itself. So the Supreme Court, in fact, I think we have already discussed this, had observed that based on Section 7(5)(b) of the IBC, it states that before the NCLT can reject an application under Section 7, it is required to notify the applicant and provide the applicant with a sufficient period of timeline. These are procedures which are already provided for under the IBC. So this is about my presentation. I'll stop sharing my screen now. Thank you so much for being such a patient listener. If there are any questions, I would be very happy to respond to them. So it seems there are no questions, or people are typing. You can also unmute yourself and ask questions. I think it would be faster that way rather than waiting to type.
Thank you, ma'am. I am CA Rakesh Tulsian, insolvency professional, and you very lucidly taken over many case law which was relevant. Just we want to know in a cut set, there are three issues which were discussed.
Yeah.
One is limitation period. One is the corporate guarantor in the case of where the CD is non-corporate entity.
Yeah.
And any other point which is main crux of your presentation?
Yes, the last one was with respect to Section 25(3).
25.
OTS gives a fresh cause of action.
Yes, 25.
Yeah.
OTS was one of the main point.
Yeah.
Any others, ma'am?
I think these are the main points. I think if you see the way the entire the legislation has evolved with respect to limitation. First, the stand of the NCLTs used to be that there is the Limitation Act is not applicable. From there on, when we reach to the stage where it is applicable because of pursuant to the amendment, and even before that, there were various judgments in which it was made applicable, especially the residuary Section 137 of the Limitation Act was made applicable. Even then, in what circumstances? So I think the evolution has been in a very phased-wise manner. Now, in terms of the judgment which has come in the case of Kotak Mahindra, my personal view is that I think this probably brings an end to the entire issue of limitation. When will it be applicable? In what circumstances will it be applicable? And what are the conditions in which it will be applicable? I think it takes into consideration the 360-degree aspect of the Limitation Act. I do not foresee there to be any reason left now for the courts to get into limitation. But of course, the law is evolving, and therefore we are also learning in the process. But for now, I think it has taken into consideration all of the possible aspects that are required to be taken. Any other question?
Thank you so much, sir, ma'am, for taking the session. It was very informative. Thank you, ma'am.
Thank you. Thank you so much. Thank you everyone for being such a patient listener.
So the next session will be taken by S Badri Narayanan. Sir is a qualified chartered accountant, company secretary, and have a Bachelor of Law from Delhi University. He has experience in advising on statutory audits of listed entities, internal control risk assessment, and corporate governance compliance, apart from leading expert teams on corporate insolvency resolution and liquidation under IBC, with core expertise in resolution and out-of-court settlement. Sir has not only been a speaker for ICAI on case study series webinars, but also assisted ICAI IBC committee on various concept papers, FAQs, etc. He holds experience and expertise in corporate insolvency resolution process and liquidation process and handling multiple successful resolutions in the insolvency regime. Sir will be taking the session on 2 Supreme Court cases, Sudarshan Bhatt, liquidator of ABG Shipyard versus Central Board of Indirect Taxes and Customs Civil Appeal number 7667 of 2021, and IBC Singapore Private Limited versus Committee of Creditors of Educom Solutions Limited and others, Civil Appeal number 3224 of 2020 and other appeals. Sir, you may now start the session.
Thank you, Anu. Very good afternoon or probably early good evening to all of the participants here. I hope I'm loud and clear. Anybody
Yes,
can? Thank you so much. So let's be point blank. In my session, you are free to speak whenever you want to, put anything on the chat box whenever you want, right? And I like this to be a very interactive session where we share from the experiences and interpretations of each other. It's not a one-person speaking session. It's going to be, interactive two-way speaking session. So I picked up 2 cases because these 2 cases are quite relevant, the way the dynamics of IBC is moving these days. So an overview, one case is very recent, and this is whether a customs authority can do recovery action when a company is under IBC. So that is on Mr. Sundaresh Bhatt, liquidator of ABG Shipyard versus Central Board of Indirect Taxes and Customs. So the conflict between IBC and customs duty has been very well laid down, and what RP is supposed to do, what customs authorities are supposed to do, what is their jurisdiction under Customs Act if there is a conflict. So all of us know section 138 of IBC stipulates that in case, the wording itself in the section is notwithstanding anything, the non-obstante clause, if there is some provision inconsistent with that of IBC, then only IBC will prevail. When IBC came in 2017, 18, and everybody was of the impression that, IBC is there, no other act will apply. People used to even skip board meetings and AGM saying that Companies Act, we don't have to comply. A lot of presidents came, judgments came which said you have to comply with all the laws. Even IBBI issued a circular where it said RP is mandated to comply with all applicable laws. And there was an insertion in section 17 of the code itself, which said that RP is mandated and it is his duty to comply with all the applicable laws. So section 238 says that if something inconsistent shows up from some other provision in some other law, inconsistent with provision of IBC, then such other law should give way to IBC. It never says that IBC is supreme, it will override everything else that has been written by the legislature. So this case typically deals on the Customs Act, the powers of the Customs Authority, the role of RP, how an assessment should be done when a company goes into IBC. It also deals with how NCLT. So in this case, some goods were in the bonded warehouses of the customs. Some duties were not paid by the company. The company went into CRP, and the RP wrote to the Customs Authority to release the custody of the goods. NCLT gave an order in favor of the RP. Then the customs, they appealed it in NCLAT, which reversed the order of NCLT, and it said that corporate debtor does not have ownership rights of the goods because they never claimed the goods. They did not clear the bill of entry, and they did not follow the procedure under Customs Act to release the goods from the warehouses. So the ownership never transferred to the corporate debtor. Hence, the Customs Authority have every right to sell the goods. under Customs Act. That was held by NCLAT, Honorable NCLAT. Then this was appealed in Honorable Supreme Court. Supreme Court, they upheld the NCLT order. They basically said there is an inconsistency in this circumstantial situation where we have to evaluate what the inconsistencies are, and ultimately they held that IBC will override Customs Act in this facts and circumstances, and RP will get back the custody of the goods. RP had become the liquidator, so liquidator will get back the custody of the goods. He will include them in the liquidation estate. Customs authorities' limited jurisdiction is to determine the value of penalty, interest, levy, fine, whatever, and then file it as a claim form before the liquidator, and they cannot initiate any recovery proceedings because that will be in the teeth of Section 14 of IBC moratorium or Section 33 subsection 5 again of IBC liquidation moratorium. So they say if you allow something to recover by the custom authority when IBC proceedings are already on, this will defeat the very purpose moratorium was brought in. So they go into deep into the ILC report, BLRC report, unicitral model law, why a moratorium should be brought in, go into Section 238, provisions of Customs Act, Section 71, 72, 45. So I don't make PPTs for case laws because being LLB, I prefer that we read from the bare judgment, because a lot of interpretation comes upon subjective reading, right? I read something, I may have different interpretation. You read something, you might have your own opinion. Go through the bare act is the best way to understand what the judgment really wants to deliver to you. I've highlighted certain paras in this, most of the paras. I will take you through them. The second judgment I've taken is I will be doing that from the summary IBBI has provided. That's on EBICS. So this came somewhere in September 2021. Why that is relevant is that crystallized the law on withdrawal of resolution plan by resolution applicant. In Maharashtra seamless case, versus Padmanabhan Venkatesh, Honorable Supreme Court said two aspects they decided on. One is a resolution plan can be below liquidation value. Nowhere the IBC says the resolution plan has to be above liquidation value. It can be below liquidation value. Second is they said Section 12A withdrawal is not for resolution applicant. It is for the applicant who triggered the CRP under Section 7, 9 or 10. It is not for the resolution applicant to use Section 12A to withdraw a resolution plan. But they left open the question on when a withdrawal of plan can be done by a resolution applicant. So that question has been decided in the EBICS case, where the Honorable Apex Court went on to decide whether modification, any changes in the plan or even withdrawal of plan can by the resolution applicant at the discretion of resolution applicant, can that be allowed under IBC or not? So there they touched upon various aspects, whether resolution plan is a contract, should you treat it as a contract in the Indian Contract Act, then will you have to apply Indian Contract Act to IBC proceedings, right? And they just delve into a lot of such aspects as to why IBC is a separate code. You have particular provisions for Section 12A withdrawal. No sections have been given for such withdrawal by resolution applicant. So legislature has thought something while putting in a provision. If you allow for withdrawals and if you put in, conditional clauses in resolution plan saying that if this happens, I will withdraw the resolution plan. You put in material adverse clauses, and during COVID, a lot of resolution applicants used to put this MAC clauses, material adverse clauses, that I'll abide by the plan only if I get this, only if I get that, only if I get these reliefs. All these are conditional plans. So this judgment says that you cannot put such conditions which allows you to withdraw after the plan has been approved by the COC and is pending before the NCLT adjudicating authority. Once it's approved by the COC, it is binding, right? We say a plan approved by adjudicating authority is binding on all the stakeholders. Why at that point of time? Even when it's approved by the COC and it is put before the adjudicating authority, it's binding on the COC and the resolution applicant. They cannot back off because this will create vagueness and it will lead to a gap that no plan might pass through, and it may delay the CRP process, or if the resolution applicant is allowed to withdraw, ultimately it will result in a delayed liquidation. So couple of very beautiful lines have been put in that judgment, and they also, apart from withdrawal, they also commented on how adjudicating authority and appellate authority should keep in mind the timelines, because time is the essence in IBC, and one of the causes of failure of erstwhile insolvency framework was the time taken by the authorities. So to fix that process, IBC was brought in, and even now we see that the courts are burdened with lots of cases and they're not able to decide matters in time. resolution plan approval or liquidation scheme approvals are taking a lot of time. So the court has commented that NCLT should endeavor to abide by the timeline, and a lot of adjournments and these things should not be given, which will impact the resolution plan. I give a plan today, I see the feasibility today, you approve it after 2 years, the asset would have lost its value. There will be normal wear and tear, depreciation, theft will be there. A lot of other market dynamics also work in the place. Entire government policy can change. Industry demand supply can change. So all these things impact my feasibility as a resolution applicant. At the point of time, I've given the plan. So NCLT and CLT have been advised to stick to the timelines and ensure that a lot of adjournments are not given and the resolution plan cases are decided well within the stipulated timelines. These are the two cases we'll discuss. The first one we'll discuss a bit in detail from the judgment itself. I hope the screen is visible. Yeah.
Yes, it is.
Thank you. Right. The first case is Sundaresh Bhatt, liquidator of ABG Shipyard versus Central Board of Indirect Taxes and Customs. This is given by Chief Justice N.V. Ramana, right? And very recent judgment. So this civil appeal before the apex court, it raised out of an order passed against, out of order passed by National Company Law Tribunal, New Delhi, dated 22nd November 2021. Here, the NCLAT allowed the appeal filed by respondent, right, against the order of NCLT. So NCLT gave an order favorable to the RP to take back the custody of goods which are in the customs warehouse. And then it was appealed in NCLAT. NCLAT gave an order in favor of the department, right? Now, the RP or the liquidator, he preferred an appeal before Honorable Apex Court. That's the factual matrix of the parties involved. So ABG Shipyard was a corporate debtor. It was involved in the business of shipbuilding, right? And for doing this business, it used to import a lot of materials and a lot of items for making the ship, and then it obviously used to export the finalized material. Now, some of these goods were stored by the company in custom bonded warehouses in Gujarat and some container freight stations in Maharashtra. Bills of entry for these were submitted at relevant point of time. The company took the benefit of certain schemes. You have export schemes where you have duty drawback benefits. So company took the benefit of export promotion capital goods scheme and had an EPCG license. August 2017, NCLT Ahmedabad passed an order admitting CARP against the company and an IRP was appointed. And obviously by way of that order, a moratorium was also imposed under Section 40. Then the appellant informed the respondent of initiation. So the RP, who is appellant in the Supreme Court appeal. So when we read appellant here, it's talking about the RP/liquidator. So the liquidator informed the respondent, which is the department, of the initiation of CRP, and he sought custody of the warehouse goods. That's what we do, right? When we enter as an RP, we try to take custody and control of all the assets, whether it's lying with the department or income tax authority or SFI or ED. We have very clear-cut case laws. You have to seek custody. So here also, Mr. Liquidator sought custody of the warehouse goods, and he requested the department not to dispose of or auction the same. Then the respondent, which is the department, for the first time in 2019, after initiation of CRP, issued a notice to the company regarding non-fulfillment of certain export obligation in terms of the EPCG license and demands certain custom duties, right? Between April 2019, 2nd April and 7th April, the department issued 5 different demand notices to the company regarding non-fulfillment of export obligations. So the details have been tabulated. So these are the obligations which the department feels the company should have paid and has not paid. On April 2019, NCLT passed liquidation order. The company did not get any resolution plan, and a liquidation application was filed before Honorable NCLT, and it admitted that application and passed a liquidation order. NCLT declared that the earlier moratorium under Section 1314 shall cease, and now a new moratorium under Section 33 subsection 5 of the IBC, barring institution of any suit or legal proceedings by or against the corporate shall commence. If you do a comparison of Section 14 and Section 33, there's obviously a lot of difference. Section 14 provides for many things. You should not, foreclose or recover your security interest. Any goods in possession of the company should not be sold. So like 5-7 clauses are there. But in Section 33, subsection 5, it says that any institution of suit or legal proceeding by or against the corporate is not permissible until you get a permission from the adjudicating authority, right? So the courts here say that Section 33(5) moratorium is now imposed. Section 14 moratorium has been substituted by liquidation moratorium. And here also it bars initiation of any legal proceedings. So that includes customs proceedings. Then thereafter, the liquidator, after the liquidation has commenced, the department has filed claims before the liquidator. So for both the bonded warehouses, whatever goods were there in Gujarat, filed the claim before liquidator. They informed the respondent through its officer that commencement has proceeded and the goods. So the liquidator, again wrote to the department that since the liquidation has been commenced, at least now you give me back the goods, so I can include them in the liquidation estate, and then the distribution can be done as per Section 53. Then due to inaction from the department, the liquidator filed an application before Honorable NCLT. At this time in point in liquidation proceedings, after liquidator filed an application before NCLT that get me the custody of these goods, the department has issued a notice against the cooperator under Section 72 of the Customs Act for certain custom dues amounting to 763 crores. So we'll read all these sections which are coming. The court has put excerpts of all the sections, Section 45, 71, 72, and then IBC section also. So the department, after the liquidation has been triggered, has issued this demand notice under Section 72 without following any other procedure of law for customs dues amounting to 763 crores against 2531 bill of entries. And against this, basing this, the department has filed the claim form with the liquidator as well. Now that the application which was filed by the liquidator, seeking release of the goods by the department so he can include in the liquidation estate, was heard by Honorable NCLT, and Honorable NCLT passed the following directions. It said the department are directed to allow the liquidator to remove the material which is lying in the bonded warehouse without any condition, demur, or payment of customs duty. The department are at liberty to lodge its claim with the liquidator with regards to the customs duties which form part, and on the release of material which forms part of the assets of the company under liquidation. The department shall allow removal of goods within 2 weeks of the receipt of this order copy. Meanwhile, the department shall not proceed for auctioning, selling, or appropriating the material owned by the company for the purpose of recovery of its customs duty. So very fair and reasonable order which was passed by Honorable NCLT. NCLT also considered, while passing over Section 238 of IBC, held that the non-obstante clause, Section 238 starts with notwithstanding anything contained in any other law. So the non-obstante clause in the IBC, being part of a subsequent law, so IBC came after Customs Act, shall have overriding effect on proceedings under Customs Act. Further, looking to waterfall mechanism under Section 53, NCLT held that distribution proceedings from sale of liquidation asset shall also prevail over Customs Act provisions. The NCLT held that government dues, the claims of respondent has to be dealt in as per Section 53. So for basing this, they refer to a circular issued by CBEC, right, where they said that it was relating to Section 11E of the Central Excise Act. There is a similar provision, Section 42A, 142A under the Customs Act. These are similar provision. So NCLT relied on a circular issued in relation to Section 11E of the Central Excise Act, where it was clarified that the dues under Central Excise Act would have first charged only after the dues under provisions of IBC are covered, right? Since Section 142A of Customs Act was very similar pari materia to Section 11E of the Central Excise Act, NCLT applied the same logic and said that, recovery under IBC or the charge under IBC will have prevalence over charge created under Customs Act, if any. After this judgment from Honorable NCLT, the department sold the goods warehoused in a Surat godown for a consideration of 169 crores. So after having this judgment in hand, they sold the goods. The sales process with respect to goods warehoused in Gujarat was still undergoing, and that was challenged before the Apex Court in the civil appeal. In March 2021, the respondent filed an appeal. So the department agreed by the NCLT order. They filed an appeal before the Honorable NCLAT. NCLAT passed the impugn order, which is before the Honorable Supreme Court, where NCLAT allowed the appeal filed by respondent, set aside directions of NCLT requiring respondent to release. So NCLAT basically says the warehouse goods can be released or disposed of as per applicable provisions of Customs Act by the proper officer. So NCLAT held the case against the liquidator, and it said that you have to pay the customs duty to become the owner of the goods. And since you are not the owner of goods, since you have not cleared the customs duties in the way Customs Act deems you or tells you to do, That's why you have, you are dispossessed from the ownership. It's a deemed transfer of ownership to the department, and the department may proceed to sell it in the way Customs Act provides it, right? So this was the judgment given by Honorable NCLAT. While allowing the appeal of department, just a second, having issue with the keyboard. Yeah. So while allowing the appeal of the department, NCLAT held that the goods lying in customs bonded warehouse, they were not the company's assets, since they were not claimed nor were the bills of entry cleared. NCLAT says that by not filing the bills of entry, the company has relinquished its title of goods on the imported goods. It also held that the company is deemed to have lost its title by action of section 48 and 72 of Customs Act. As such, department is empowered to sell the goods and recover the government dues. So it refers to certain sections of Customs Act, which we'll read. And it says, since the company has not paid its duties, that's why it does not have ownership of the goods. And the Customs Department has every right to sell off the goods and recover the dues. NCLAT also held that the imported goods which are subject to levy. So imported goods which are subject to levy of customs duty, they stand on a different footing as payment. So what they are saying is, since you imported the good, there is a consequent customs liability. This consequence of the customs duty is different than a liability which you normally see under IBC. So you cannot call it operational debt. So since you import, you have to pay a customs duty under Customs Act, and you cannot treat it in the same fashion as you treat any other operational debt. NCLAT also held that the Customs Act is a complete code which provides that warehouse goods cannot be released under import duties are paid. So you pay the duties, then only you get the release of the warehouse goods. It says, since the department filed, claim form before the liquidator, there was one point of contention that, since the department filed claim form, it accepts that ownership of the goods rests with the liquidator or the company. So NCLAT had held that, simply because somebody has filed the claim form does not mean there's a relinquishment of right of the department before the warehouse goods. So he claimed because he wants to realize his dues, and it does not mean that he has relinquished his right in the warehouse goods. That's the NCLAT's view on this. Over the issue of priority of IBC over Customs Act, NCLAT held that the issues did not arise in the present case as the goods were imported prior in time to the initiation of CRP. They say that since the goods were imported prior between 2011 to 2015, CRP started in 2017. That's why this question of which is supreme, IBC or Customs Act, that does not come into play. By not paying the import duties, corporate debtor company has lost the right to warehouse goods prior to initiation of CRP itself. NCLAT held that these warehouse goods stand on a different footing and cannot be considered assets of the company. They say, since the company lost its right over the goods, since it never claimed or cleared the bill of entries, it cannot say it has ownership of the goods. Even before CRP, it did not possess ownership of the goods. Agreed by the above, an appeal was preferred before Honorable Apex Court by the liquidator. So we look at the contentions of what both the sides of counsel placed before Honorable Supreme Court. Mr. Arvind Dattar appeared on behalf of the appellant liquidator. So he contended that the company is the owner of goods. Section 48 of the Customs Act, it states it applied to goods which are neither cleared nor warehoused by the importer. So Mr. Arvind Dattar says that the notice issued and the claim form filed does not in any manner attract Section 48. What is Section 48? We'll come down when we flip the pages, we'll come down and read that. So he basically says that Section 48 of Customs Act is not attracted simply because a notice was issued under Section 72 or a claim form was filed. He says the company has not lost ownership of the goods by issuing notice under Section 72 and by filing a claim form. The department agrees that the company has ownership of the assets. By submitting claims under Section 38 of IBC, the department has elected to subject its dues to be gone by IBC, and more specifically to the distribution matrix provided under Section 53. So when you're filing claim before liquidator, you are submitting yourself before liquidator to be gone by Section 53 of IBC. The claims made by the respondent before the appellant are based solely on the corporate debtor's ownership of the goods. So he says the department cannot blow hot and cold at the same time. One place it files a claim, submitting that it agrees that the company has ownership, and in other place it issues a Section 72 notice and says that I'll go and sell off the company's goods because the company does not have ownership and the department is the deemed owner of those goods. So the counsel for, liquidator says you cannot do hot and cold at the same time and take contrary stance. The department could not have exercised its right under Customs Act as the statutory charge of the department under section 142A of Customs Act. So I just told section 11E of the Central Excise Act, there was a circular issued, which, says that the charge will be, subordinate to the charge under IBC. So section 11E is pari materia to section 142A of Customs Act. So the council contended that the statutory charge under section 142A of Customs Act is subordinate to the IBC. Then he says that the custody of company is good by the department. That's in direct violation of section 14 and section 33 of IBC. Section 14(1)(a) of IBC expressly prohibits institution of or constitution of proceedings against the company during moratorium. Further, 14(1)(c) states that foreclosure, recovery, or enforcement of any security interest is prohibited. So he says even the custody which the department is maintaining over the warehouse goods, that is illegal and that is violative of section 14 and section 33 of the code. Now we had Senior Advocate Mr. K.M. Nataraj, learned Additional Solicitor General of India. He appeared for the department and these were his submissions. He says that the goods were left in the custom bonded warehouses. They were not assets of the company. They were never claimed after being imported. The bill of entry were never cleared and the company abandoned all the material lying in the warehouse. He says despite receipt of various demand notices, the company did not clear the goods. Hence the same are liable to be sold under Customs Act. He says the liquidator can take into possession only assets of the company. However, in the present case, warehouse goods cannot be termed as assets of the company until and unless they pay the dues against such clearance of warehouse goods. He says section 45 lays down restrictions on custody and removal of goods. It stipulates that all imported goods shall remain in custody of such person approved by the Commissioner of Customs till the time the same are cleared for home consumption or warehouse or transit. So there are like three things which can be done when you import a good. So either you use the goods off or you warehouse it, right? So you clear it for home consumption or you may be, clearing it and then exporting it out somewhere else. That's called transshipment. So he says section 45 lays down certain restrictions and it tells how the goods are to be cleared. And it says that if such goods are not cleared as per the criteria mentioned above, they can be sold after permission of proper officer. Section 71 of the Customs Act. Section 71 of the Customs Act further states that no goods shall be taken out of the warehouse except as provided under Customs Act. So he is putting his points in a manner that Customs Act has to be followed. It's a complete code in itself and it has to be followed and it will have prevalence over IBC in this case. Hence, the goods cannot be removed without payment of import duties and charges. He also states that the company has abandoned the goods, refused to pay the duties and charges, and has not taken any effort to take possession of goods for several years. Consequently, the company has lost its right to the warehouse goods. Hence, under section 72, that's the section under which the demand notice was issued for sale of the goods. So hence, under section 72 of the Act, government authorities are fully authorized to recover the dues. In such a circumstance, where the company's title to the goods has been deemed to have been relinquished, the liquidator does not have authority to take possession. So again, he's contending the company already lost its right on the goods long back because it abandoned the goods. Since it abandoned the goods, there is no ownership of the assets by the company. Since there is no ownership of the assets, the liquidator cannot take custody of such goods from the department. He says customs duty is an incidence or consequence of import. So since you imported, there is a consequential customs duty. So he says even before CRP was initiated, corporate debtor could not have, so basically what he's saying is, if you wanted to get the goods cleared and get it in your name, you should have cleared the customs duty for importing it under section 45, that was section 71. If you have not done that, you don't get ownership of the goods. Then he says that the company has abandoned the goods, not taken any efforts, and it's an incidence, all that thing. And he says that merely because the department had filed its claim before the liquidator, it cannot be said that the department has relinquished its right over the warehouse goods. The claim was filed only to realize the dues and cannot be viewed as relinquishment or abandonment in its right. So it's not like normal section 53 where we say, a secured creditor, if he says in the claim form that I relinquish my rights and he gets governed under section 53. So here the council says that, simply filing of claim form does not mean he has relinquished his right over the goods under its possession. It can still sell the goods under Section 72 of Customs Act. So the Honorable Apex Court framed two questions based on the submissions. These were that whether the provisions of IBC would prevail over the Customs Act, and if so, to what extent. Whether, and when deciding this, they said, NCLAT, rather than going into question of law on this aspect, they rather went into question of facts on, what was the time period when the goods were imported, not cleared, and they delivered the judgment based on those facts rather than addressing the question of law. So whether the provision of IBC would prevail over Customs Act, if so, what extent? Second question is whether the respondent department could claim title over the goods and issue notice to sell the goods in terms of Customs Act when liquidation has been initiated. So the Honorable Apex Court went into a very detailed analysis of the issues at hand. It says that the department has relied on certain provisions of the Customs Act, right? And certain stands have been taken by both the sides. So it says the Honorable NCLAT has not directly answered the question of law. Rather, it entered into facts of the case to distinguish between applicability of IBC as compared to Customs Act. NCLAT has held that corporate debtor has abandoned the goods much before insolvency process was initiated. Thereby, the title has passed to the Customs Authority. Now, when we read more in detail, it will be written that you say that goods have been abandoned, but even such abandonment should be by a due procedure of law. Were there any scrutiny done, any orders issued, any notices issued, any opportunity of being heard was given? You cannot simply say somebody left the goods so it got abandoned. So Honorable Apex Court goes on to say that, although NCLAT says it was abandoned, it did not consider the aspect that no procedure of law, due procedure of law was followed to even termed as abandoned goods. So here they have, reproduced the excerpts from the NCLAT judgment. So NCLAT said that it is clear that NCLT, NCLAT cannot usurp the legitimate jurisdiction of other courts, tribunals, when the dispute does not arise solely from relating to insolvency. So if it relates to insolvency, come to NCLT, NCLAT, otherwise we cannot interfere in other courts. This was what Honorable NCLAT said. In the instant case, corporate debtor had abandoned the imported goods for several years, failed to pay import duty and other charges, and had not taken any steps to take possession of those goods for several years. Therefore, the importer has lost his right to the goods. Consequently, Customs Authority are fully empowered under Section 72. That's a section wherein you can sell the goods off and recover custom dues. Section 72 of the Customs Act, to sell the goods to recover the government dues. The liquidator has no right to take into possession over those goods for which the company's title is deemed relinquished by implication of law. This is what Honorable NCLAT said. Further, the judgment of NCLAT also stated that appellant has filed its claim before the liquidator. That means the department has filed the claim before liquidator. It relied on certain Supreme Court judgment and said that it is clear that submission of claim in response to a notice by liquidator. So liquidator issues a public announcement inviting for claims. Says that the submission of claim in response to notice issued by liquidator cannot be presumed that the department had relinquished its right over the property and submitted to jurisdiction of liquidator. So the claim filed is an effort to realize dues. This is what Honorable NCLAT says. The claim is filed to realize the dues. It will not amount to relinquishment of rights over the warehouse goods under its custody, and the department has every right to sell it under Customs Act. And he goes on to say that the company's assets, because the company never made any effort for clearing the goods, so it says that company has no right over such imported goods where it did not pay any duties and did not take any effort to get back the ownership of the goods. The containers were imported between 2012 to 2015. CRP was initiated in 2017. Liquidation was passed in 2019. Thereafter, the assets lying in the customs bonded warehouse cannot be considered as assets of the company. Goes on to say that therefore imported goods subject to levy of customs, they stand on a different footing than the goods or assets not in the company's possession. So when you read liquidation estate definition, it also includes goods which the company has ownership of but does not have possession of. But here it says the imported goods subjected to levy, where levy has not been paid, stands on a different footing than the goods which are not in the company's possession. Hence, assets lying in the bonded warehouse of the Customs Authority cannot be considered as company's property. Right. In this context, the Honorable Supreme Court said, let's analyze whether NCLAT's treatment of fact is correct or not, and whether they need to relook at the way NCLAT has delivered the judgment. So it says that when goods are imported or exported from India, they are charged to customs duty. It says, before going on to IBC and IBC versus Customs Act, let's read some provision of Customs Act. It says when goods are imported or exported, they are levied to certain customs duty, and the reasons might be different. It can be trade control, prevention of smuggling, protection of the domestic industry, etc. It also says that when goods are imported, it can either be for home consumption, that means domestic use, or it can be for transshipment. I bring it here to take it out somewhere else. An importer can either choose to pay the duty and utilize the goods immediately for domestic usage, or so either I choose to pay the duty immediately and take the goods, clear the goods, and do what I please with them, or I execute a bond, keep it in a customs bonded warehouse. Accordingly, an importer has to submit a bill of entry either for home consumption or for warehousing in terms of Section 46 of the Customs Act. When a person chooses to warehouse the goods, he ought to execute a bond in terms of Section 59. Such warehouse goods can subsequently be cleared for home consumption or can be exported. So I'm just, as a temporary facility, I'm using the customs bonded warehouse, executing a bond, keeping it there. Tomorrow I can get it released for whatever use I want to go for. Section 61 of the Customs Act mandates that time period allowed for warehousing. So for capital goods, it says, till such goods are cleared, you can keep it for 100% export oriented. In case goods not intended for such export oriented purpose, a time period of 1 year is given. If you keep it more than 1 year, you have interest clauses which kick in, and you have to pay interest for keeping the goods warehoused more than the prescribed period. Section 72 has been reiterated by the Honorable Apex Court, because this is the section under which the demand notice was issued by the Customs Department. Section 72 of the Customs Act talks about goods improperly removed from the warehouse. It says in any of the following cases: 1, where any goods are removed in contravention of Section 71. 2nd, where goods have not been removed from a warehouse at the expiration of the period which they are subjected to, say 1 year period. Then goods in respect of which a bond has been executed, warehouse, and which have not been cleared for home consumption or export, or not duly accounted for to the satisfaction of proper officer. The proper officer may demand, and the owner of such goods shall forthwith pay the full amount of duty chargeable on account of such goods, together with interest, fine, penalty payable in respect of such goods. Then comes the main clause, subsection 2. If any owner fails to pay any amount demanded under subsection 1, proper officer may, without prejudice to any other remedy, cause to be detained and sold after notice to the owner such sufficient portion of the goods in the warehouse as the officer may deem fit. So this is a section under which the customs issued the notice, and they said that since you have not paid the dues, we are going to sell off the goods to recover the duties. So the Honorable Apex Court said that officer has to take steps in terms of Section 72 subsection 2. That means first he has to identify the quantum of what assessment of duties are there, how much penalty interest is there. Only thereafter he can go and he can invoke the provisions for sale of goods. In order to complete the discussion on the Customs Act, the Supreme Court also evaluated Section 142A, which talks about first charge in the given context. It says that liability under Act 2 a first charge, notwithstanding anything to contrary contained in any act, any amount of duty, penalty, interest, or any other sum payable by an assessee or any other person shall save as otherwise provided. That means subject to in Companies Act or RDDBA Act and IBC, be the first charge on the property of assessee or the person, as the case may be. They say the liability under the Customs Act will be the first charge on the property of the company or the person concerned, subject to provisions of your RDDBI, Companies Act, and IBC. So since they have put in IBC here, and since Section 238 is also there in IBC, that gives prevalence to IBC. In the present case, the company, as part of its business, used to regularly import warehouse goods, etc. And the Honorable Apex Court just dwells on the fact, saying that, okay, 2011 to 15 they might have imported, 2017 they came into CRP. But they say that from the record, it appears no notices were issued by the department against the company prior to initiation of CRP. So the Apex Court from the record holds that any notice or all the notice issued were subsequent to initiation of CRP. They say all the duty demand notices issued by the department were from March 2019 onwards. It is necessary for us to ascertain whether IBC overrides Customs Act or not. They say, then they go on to IBC's provision. They say, IBC was brought in 2016 to combine all provisions of insolvency law to avoid duplicacy of multiple framework. And they say that let's have a brief look at various stages in IBC. They go on talk about triggering of IBC petition. They say section 7, 9, and 10 is there, where somebody can approach NCLT and trigger insolvency. Then they say that upon insolvency being triggered, a 180-day period is given where the claims are freezed. And during this period, NCLT appoints a resolution professional who aims at activities to revive the corporate debtor. Then they say that CRP must normally be completed within 180 days and the COC takes decision for insolvency resolution. Then they go on to section 14. So they say when a case is admitted into CRP, NCLT is mandated to declare a moratorium. Then they read about moratorium. So moratorium 14(1)(a) talks about prohibition on institution of suits or continuation of suits proceedings, etc., which is very similar to section 33(5) of the code as well. It also states there is a prohibition on any action to foreclose, recover, or enforce any security interest created by the company in respect of property. They explain the entire section 14's gamut, and then they say that section 14. So these are the important lines. It says that they prescribe a moratorium on initiation of CRP and its effect. One of the purposes of moratorium is to keep the assets of the company together during CRP process and to facilitate orderly completion of the process envisaged under the statute. So these lines, they bring it in from ILC report February 2020, which also talks a couple of sentences about moratorium. The ILC report had stated that the purpose of moratorium is intended to keep the assets together, facilitate an orderly completion of the processes, and ensure that the company can be run as a going concern. The ILC report also stated the UN Citral guide, which states that the moratorium is critical during reorganization proceeding since it facilitates continued operation of the business and allows debtor breathing space to organize its affairs. So even if during this moratorium period you go on continuing legal proceedings, company or the RP appointed cannot go about finding a resolution plan or ensure going concern. The Apex Court said from above ILC report, it can be seen one of the motivations of imposing a moratorium is to give a shield that protects the company from pecuniary attacks, financial pecuniary attacks against the company. So the company has a breathing space and allows it to run as a going concern. Then they also go into section 33, subsection 5 of IBC, which also talks about the moratorium, saying that no legal proceeding should be initiated by or against the corporate debtor without permission of the NCLT. Now they say that IBC being a more recent statute, it overrides the Customs Act. And they say, read section 142A and read it with 142A of the Customs Act, which talks about, first charge of asset subject to proceedings under IBC, and read section 238 of IBC as well, which gives IBC an overriding effect. So it says that Honorable NCLAT, while, playing down the effect of 142A and 238 of IBC, has held that the Customs Act is a complete code and no person can seek removal without paying of duties. So Apex Court says, while the NCLAT has relied on certain judgment and a judgment which says, Customs Act has prior charge over the assets of the company, he did not see that IBC is there in the run, and all these notices by the department were issued after initiation of CRP proceeding and liquidation proceedings, and that 142A of Customs Act has a specific carve-out for IBC, and there is section 238 also, which has to be appreciated. From the above, it is to be noted that the Customs Act and IBC act in their own spheres. In case of any conflict, IBC overrides. So the court says now we have to ascertain whether there is a conflict in the operation of two laws in the given circumstances. Court says first we'll do a harmonious interpretation, and if you find conflicts, then we'll check IBC prevails over Customs Act or not. Again, they state that the demand notices by the department, they are clearly violative of section 14 as they were issued after initiation of CRP. They say moratorium was imposed in 2017. The first notice was sent by the department in 2019. And thereafter in 19, NCLT itself passed a liquidation order, and there is a moratorium under section 33(5). Only after this liquidation order, Customs Department has issued that notice under section 72 of Customs Act for sale of warehouse goods in its possession. So the various demand notice clearly issued after insolvency proceedings, with some notices even after initiation of liquidation proceedings. The court says that we are of the clear opinion that the demand notices seeking enforcement of dues during moratorium would clearly violate provisions of section 14 or section 33 moratorium provisions. They say that the above analysis would not be complete until we examine the powers of the authorities. So while we say that they are violative of section 14, their actions, we also have to go into what domain they can operate in. So the court refers to its judgment in SV Kundaskar and VM Deshpande 1972 judgment, where in this judgment basically the court held that you used to have liquidation under Companies Act. The court said in that judgment is the liquidation court cannot step into the shoes of income tax officer, take the role of income tax officer and assess the duties. So the assessment of duties will be with the income tax officers, right? And that claim will come to the liquidator, and then the liquidator court can decide to what extent the claim has to be admitted. But it cannot get into the character of the income tax court or income tax officer and sit to decide how much the claim should be. That role should be left to the income tax authorities. So the court here referred to this judgment, and they said that the authorities can only take steps to determine tax, interest, fines, penalty which is due. Authority cannot enforce the claim for recovery or levy of interest on tax due during period of moratorium. They say that the above judgment squarely applies here. So let the authorities determine the dues, but they cannot enforce recovery. We hold that the department could only initiate assessment or reassessment of the duties and other levies. They cannot transgress such boundary and proceed to initiate recovery in violation of section 14 of IBC or section 33 subsection 5 of IBC. IRP, RP or liquidator has an obligation to ensure such an assessment is legal, and he has been provided with sufficient power to question any assessment. So tomorrow department issues a notice to the liquidator RP. RP, if he feels that such investigation by department is excessive, he has all rights to question, and he has to ensure that the assessment being done is legal. Legal means notice itself should be legal. First of all, they are issuing a legal proceeding under moratorium, that is itself violative of section 14. When the notice itself should fall off, there is no question of determination being done there. But more wrong is enforcing of claim or enforcing of recovery by suo motu action by the department. That forming part of assessment is illegal. That should not be allowed by the RP, and he is left with legal remedies to approach honorable NCLT in cases such department enforces security action. There is another aspect of case that needs to be highlighted: inconsistencies between Customs Act and IBC during moratorium. So they say that demand notice was issued on July 2019 under section 72. This is in clear breach of moratorium under section 33 subsection 5 because liquidation order was already passed. Issuing a notice under section 72 of Customs Act for non-payment of duties falls squarely within the ambit of initiating legal proceedings against the company. Even under liquidation process, liquidator is given the responsibility to secure the assets under section 35. So liquidator has the duty of forming liquidation estate. He has to secure the asset, take the goods into his custody. As laid down earlier, Customs Act and IBC can be read harmoniously, where authorities under Customs Act have a limited jurisdiction to determine the quantum of operational debt. In this case, the customs duties, in order to stake claim in section 53 of the code. So their limited jurisdiction is to do an assessment or reassessment of whatever is due to them so that they can file the claim and sit in line with other creditors under section 53. They also referred to Gujarat Urja Vikas Nigam Limited Supreme Court case, where balance was struck between jurisdiction of NCLT in IBC and other authorities. But Honorable Supreme Court says the NCLAT did rely on Gujarat Urja Vikas Nigam case, but they misinterpreted the idea of the case. Honorable Court said such interpretation ignores the fact that there was no abandonment of goods. So here's where they say that it says that NCLAT did not consider the fact there was no abandonment. It straight away went on said and there's abandonment of goods. But how did it decide that it was a legally enforced abandonment? It says such interpretation ignores the fact there was no abandonment, which would authorize the customs to initiate adjudicatory process to transfer title. Before any goods can be declared to be abandoned, the same must be adjudged by some authority after due notice. So Honorable Apex Court says you have to follow due procedure of law. This position of abandonment cannot be assumed or deemed. In case at hand, no adjudication or notice has been placed on record, to suggest that such abandonment of goods had taken place prior to imposition of moratorium. So department could not give any evidence that any due procedure of law was followed to call this abandoned goods to get the transfer title to themselves. NCLAT, by deciding question of passing of title from the company to the authority, clearly ignored the mandate of section 72 subsection 2 of Customs Act. It clearly ignored the effects of moratorium under IBC. The fact is that the duty demand notice and notice under Customs Act were issued during the moratorium period, and this has resulted in moratorium otiose. Otiose means practically irrelevant. By allowing issue of notice under moratorium, we have left the provision to be practically irrelevant now. The interpretation provided by NCLAT regarding deemed transfer of title of goods from company to the authority would fly in the face of section 14. They said completely defeats section 14. Moreover, such deemed transfer cannot be countenanced law, and it's violative of Article 300A of the Constitution, as the properties are deemed without there being adequate hearing or adjudication of any form. So, if you say abandoned goods, there was a due procedure of law followed, post which ownership was transferred, that is valid. But without having any adequate hearing or adjudication of any form, if you call it a deemed transfer, it is violative of Article 300A. They say, interestingly, in the present case, the customs authorities filed Form C under liquidation regulation, and they offered themselves to be bound by section 53. The department does a U-turn on filing such claims, and instead unilaterally issues a notice under 72 subsection 2 and says, I'll sell the asset and recover the money. So it say there, by filing issuing a notice under 72, it says there is a deemed transfer of title to my department, and now I have the right to sell the goods. And in one place, it's filing claim form before liquidator and accepts the ownership of the corporate debtor of the goods and submits itself to section 53 of the code, right? So the sake of clarity, the Honorable Court said, let's issue the answers one by one. So on whether provisions of IBC would prevail over Customs Act, they said definitely IBC would prevail over the Customs Act to the extent that once moratorium is imposed, the respondent authority has a limited jurisdiction to assess, reassess, determine the quantum of duties. They do not have the power to initiate recovery of dues by sales of confiscation. That is one part. Second, whether the respondent could claim title over the goods and issue notice to sell goods in terms of Customs Act when liquidation is underway. They answered this also in the negative. It says the once moratorium under 33 subsection 5 is in place, the department has a limited jurisdiction to assess, determine the customs duties. They do not have power of initiating recovery. After such assessment, the authority, the department has to submit its claim in terms of procedure laid down in IBC within strict timelines as given under IBC. In any case, IRP, RP liquidator can immediately secure the goods from the authority to be dealt with appropriately. So any case you face where such a notice has been issued or goods have been taken in custody by PMLA authority, CD, SFA, whoever, you have to write to them, get the custody back. Resultantly, we allow the appeal, set aside the judgment of Honorable NCLAT. So very clearly, in short, customs authorities or any other authorities on the same ground, they can very well assess, reassess, determine the duties, fines, interest, levies, everything which is payable to them under Customs Act. But they cannot say, I'm going to sell the asset of the company in my possession to recover the dues. Their limited jurisdiction is to determine the dues and file claim form before IRP, RP or liquidator. They do not have any right to sell the assets once moratorium is there in the picture. So this was the case on Sundaresh Bhatt versus ABG Shipyard and Central Board of Excise. Any questions on this, or I can just briefly go to the other case also, then we can take questions on it. I'll take 5 minutes for the other case. It's longer, but
Sir,
yeah.
Sir, I have one small doubt.
Yes, sir.
So PF authorities, any authorities, they can assess during the CIRP process or liquidation process, and they can issue the assessment order during the CIRP process, sir?
They can very well, sir. In your EPF and gratuity, there is also a case from Honorable NCLAT in Lanco Amarkantak, I believe. That's a case where they say, the dues payable to employees, gratuity and all, they even come above secured creditors and they have to be paid in priority. So so they can very well assess.
No, only doubt is lot of the assessment orders are coming during the CIRP process.
But if it's for a prior period, ideally it should come by way of claim form. They can do assessment.
Because
prior,
one of the stakeholder is contesting that As the assessment
I
proceedings
got your
is
point. Got
What,
your
sir?
point. Since assessment order came during CRP, considered as a CRP cost.
No. As it is came during the CARP process, you cannot accept. You deny the claim.
No, it's not like that, sir.
Okay.
So even if you read all the case laws from NCLAT, NCLT on PMLA, SFIO, ED relating to all these things also, they say that RP has to assist the assessing officer or the authorities in giving all the information which he has. He cannot say moratorium is there, I'll not even let assessment happen. Even in this case, the Honorable Court says assessment, reassessment should be allowed. RP should cooperate. Whether there is illegal assessment, there RP has the right to question. But you have to cooperate, you have to give information on the assessment, sir. That can
We are giving, sir. We are giving. Only point is assessment order assume after 5 months of CARP commencement is completed, and then they are giving the claim form. So stakeholders are saying the claim forms are supposed to be considered as on the date of CARP commencement date based on the information or assessment is happened before date, but not later date.
Okay, so here the complication will be two aspects. One, it should be cutoff date, ICD date. We have to request the authorities that any claim has to be on ICD date.
They are
Second,
giving ICD date, but
date.
based on the assessment is completed
That is okay.
subsequent to the date. Is it
That
okay,
is
sir?
okay. Which is okay, sir. Which is okay. Because what happens is, if they have given their claim before consideration of resolution plan by COC,
Yeah.
and if you don't consider it, they will file an application in NCLT. It will be stuck off. Unnecessary delays will be there.
Yeah, correct.
In many cases, NCLT has said when plan itself has not been considered by COC, what is the issue of RP to accept the claim?
That is correct. But stakeholders are saying proceedings. Section 14 says proceedings also stop. So all these will come under proceedings. So you cannot accept karke refuse.
That will be very regressive to labor laws, sir, if we take that.
No, I am not saying only labor laws, GST,
any law, sir.
Excise, all those.
So GST authorities also have a circular issued where they say, you identified use file claim form before the RP. I think it's the only department which has issued such a very detailed circular on what the debts will be. It will be operational debt. You have to file the claim before the RP. They have come out with this. But in case assessment could not see, ICD comes suddenly. Okay, there will be a case pending in NCLT. Suddenly CRP would be initiated. ICD will come. We cannot expect our departments to finish all assessment and be ready to file claim form.
Before date.
Correct.
That is the thing. Correct.
So let the claim come. Why unnecessary litigation?
Yes, sir. Correct.
Yeah.
Yes.
Somebody else was also stating something. Or I'll just project the next one also, quickly finish it off. Any other questions on this case which we discussed? No questions. Did I confuse all of you or? Okay, was I clear on the judgment? I'll just share the other one also then. So the next one, I hope the screen is visible. So this is a September 2021 judgment, a bit old, but very relevant. So here the Apex Court held that once resolution plan is approved by COC and submitted to NCLT, after due compliance with procedural requirements and timelines, successful resolution applicant cannot withdraw or modify the plan. The Apex Court emphasized that the speed of resolution as contemplated under the code is sacrosanct, and adjournments in the proceedings hamper the efficacy of the judicial process. It further held that NCLT and NCLAT, the adjudicating bodies under IBC, they should be sensitive to the effect of such delays and should endeavor on best effort basis to strictly adhere to the timelines stipulated under the code and clear the pending resolutions forthwith. So nothing new. Everybody knows how much time the courts are taking, not because of their own fault. The ecosystem is still developing. The infrastructure has still to be developed. You have a lot of vacancies lying. You have multiple cases, multiple litigations. And even before an order comes, an appeal is ready. That's how the scheme of things work now. So here in this case, first issue which was addressed is whether withdrawal of resolution plan by a successful resolution applicant is allowed. Second, it was a comment and it was a recommendation on the adjudicating authority and appellate authority to speed up at least hearing of resolution plan cases. So they went, it's a very detailed order. I think it's a 190-page judgment. IBBI comes up with these summaries, which are quite useful. I only refer to them to refer to the page numbers and the para numbers, which, might have, relevant text. It's always better if you refer to the original judgment. So the Supreme Court goes on to explain the purpose of the code. They say IBC was a landmark law which was brought in, comprehensive framework which was brought in. And they say one of the two important sources of delay, which were there in the previous frameworks also, was that, the courts were not deciding on time. So that's why speed in IBC is the essence of resolution. You have to follow and stick by the timelines given in IBC. It says that law mandates conclusion of CRP within 330-day outer line period, including litigation. However, there is some discretion on exceptional cases. So somebody files a case on 330th day, you cannot expect the courts to complete pleadings, hearings, everything, and issue an order in one day. So in exceptional situations, courts may take certain time, but this discretion must be exercised sparingly and only in the situation envisaged in SR Steel case, which was a landmark judgment. It says if CRP is not completed in time, company is sent into liquidation, right? And we have to understand the framework of the law, the judicial, when they say the judiciary has to understand the economic framework of the law to, stick to the timelines and what effect it can have on the market dynamics if we try to invent some process which is not even given in the law. So basically they are saying the law does not state that withdrawal of plan is allowed by a resolution applicant. If courts intervene and give that remedy, they will disturb the very framework of the code. They will disturb the very essence of the code, which gives certainty over, a revival of corporate data. Somebody gives a plan, it's approved by COC, it's pending before NCLT. Now, if the NCLT allows that person to withdraw the plan, they are doing something which is not expressly provided in the code. By doing that, they are, like filling a gap in the code, which is not meant to be filled. And that again leads to uncertainty where IBC resolution objects, everything fails off. Then they go on to talk about adjudicating mechanism under the code. They said the procedure designed for insolvency process is critical for allocating economic coordination between the parties who are bound by the process. So the parties include all the stakeholders here, the creditors, employees, everybody. Upholding the procedural design and sanctity of process is critical to its functioning. Interpretative task of courts, even Supreme Court, must be cognizant of allied with that objective. They are saying you have to keep in mind the design of the code before going on into your interpretative skills and giving some order which might not be the intent of legislature in the first place. Any claim seeking an exercise of the NCLT's statutory power under section 60 subsection 5 or inherent power under NCLT rules or even powers of Supreme Court under article 142 must be closely scrutinized. If somebody comes and files a section 60 subsection 5 case or under rule 11 or article 142, it should be closely scrutinized for broader compliance with insolvency framework. Then they go to talk about nature of resolution plan. So they say there are 3 stages. One stage is discussion on the resolution plan till its approval by COC. Second stage, approval by COC till approval by NCLT. And then third stage is after approval of resolution plan by adjudicating authority. So they say the first and third stage are covered by IBC, the framework of IBC. About the second stage, which is after approval by COC till approval by NCLT, they say IBC does not talk about how this is covered, right? The power of COC to suggest modifications, it has an element of negotiation, right? Which could make, when COC sits with the resolution applicant, they can always negotiate on the numbers. So there can be multiple revisions and applicants are allowed to resubmit their plans. The scope of commercial bargain with the resolution applicant evinces a sense of negotiated agreement that is arrived between parties and resembles contractual freedom by COC and resolution applicant. So when you read, since we are short on time, so basically what they say, there might be flavors of contract in a resolution plan. So issue of RFRP might be very analogous, similar to, a proposal given or interest given under contract act, right? But it is not same. IBC works in its own frame. The resolution plan works under contours of IBC, and you cannot import the provision of contract act and put it under a resolution plan. So anything related to damages, novation, all these things on contract act cannot be imported and put into IBC. A resolution plan, although has some elements of contract, like you have commercial negotiation, you might have some clauses, but it's still governed under IBC and not under Contract Act. So what one peculiar point which they made here is, if resolution applicant fails abide by the resolution plan, he is not liable to damages under Contract Act. He is liable to penal provision under IBC. So that is one more interesting point which they made to say that it's not a contract. Resolution plan is not a contract per se, and you cannot apply Contract Act to IBC. Then they go on to talk about statutory framework governing the CRP. They say a lot of legislative amendments have come from the legislature to address some gaps in judicial findings which are aligned with the framework of IBC, but does not mean that the courts decide and introduce something which is not even intended by the legislature. If withdrawal of resolution plan by applicant was intended, there would be some provision on how it has to be done, like section 12A, regulation 30A is there. We have to read it for section 12A withdrawal. That very clearly defines what all are the stages where it can be done, by whom it can be done. The legislature never intended to allow a resolution applicant such withdrawal. When the Honorable Supreme Court decided Maharashtra seamless, there also they said section 12A is only for the applicant who initiated CRP and not for anybody else, right? So similarly, when the court does not provide any provision for withdrawal by a resolution applicant, it will be improper for NCLT or even Honorable Supreme Court to allow such withdrawal, because it will disturb the entire scheme of IBC. They go on to refer some other cases like Swiss Ribbons and S Rajagopal, Brilliant Alloys, and they say this should not be allowed. They say the resolution applicant is deemed to be aware of IBC and its mechanism before it gives a resolution plan. They give plan based on information memorandum and their due diligence, right? So after giving the plan, they cannot come and change their stance now and then. A court may not be able to lay down detailed guidance how a mechanism for withdrawal, if any, may be provided to a SRA without disturbing statutory framework. They say this is the job of legislative policy, not the court's policy, to define how successful RA should be allowed to withdraw. They say that where the interpretive maneuvers of the court have an effect of transgressing into the law-making power of the legislature. So they are talking about clash between legislation and judicial power. So they are saying where the interpretation is leading to transgression of law into judiciary into legislature and disturbing the delicate balance of separation of powers between legislature and judiciary, then we should exercise restraint. We should not get into it. The court should not get into it. Since the court does not have the necessary expertise, economic expertise, nor the power to hold consultations with experts to decide the direction of economic policy. Then they say absence of any routes stipulated under the code for a successful resolution applicant is an indicative of IBC's proscription of any attempts at withdrawal at SBI. That means if IBC do not provide for withdrawal by resolution applicant, that itself is indicative IBC does not want such kind of uncertainty to be there. In the absence of any provision for such withdrawal, vesting RA with such a relief through process of judicial interpretation would be impermissible. Then they talk about, regulation 33, it says that a plan whose implementation can be withdrawn at the base of RA. They say regulation 38 subregulation 3 says plan should be feasible. If the plan itself says it can be withdrawn, it's no more feasible. IBC does not envisage a dichotomy in the binding character of the plan in relation to the RA between stage of approval. It says the binding nature of plan is binding on all the stakeholders. IBC does not say at which stage. So there is no contrary area of operation given by IBC that the plan will be binding on this stage, not binding on this stage. Once the plan has been given to COC, approved by COC, submitted to NCLT, you cannot allow the resolution applicant to make modification or withdraw the resolution plan. The binding of nature of the plan on resolution applicant, who is the proponent of the plan, which has been accepted by COC, cannot remain indeterminate at discretion of resolution applicant. The statutory framework of IBC consistently attempted to avoid situation which may introduce unpredictability in the insolvency resolution process. So they brought in so many amendments just to make sure, go down with the uncertainties. A conditionality which allows for further negotiation, modification or withdrawal once the plan is approved by COC would only derail time-bound process. So next time you check a resolution plan, I have to make sure there is no such, they call it CPs, condition precedents, and other conditions. Then they will have something on the reliefs and pay as part in the resolution plan. So nothing should be there which allows them withdrawal after the COC approves the plan, because that will be in violation of EBIC's Supreme Court order. If legislature intended to allow withdrawals, it would have given a mechanism there. parties cannot indirectly impose a condition on judicial authority to accept or reject. So it says some plans even consider that if NCLT does not accept within this time, I will withdraw the plan. So they are saying parties cannot put those conditions. While considering all this, they recommended NCLT, NCLT to keep a watch on the timelines, because a plan given 2 years back would lose its value at the current time, and that will have unnecessary impact on the resolution applicant and all other stakeholders also. So NCLT, NCLT should stick to the timelines. The residual powers of the NCLT or NCLAT cannot be exercised to create procedural remedies which have substantive outcomes on process of insolvency. The framework only enables withdrawal under section 12A read with regulation 30A, and in situation recognizing those provisions. That means only the applicant can withdraw CRP process. Resolution applicant cannot withdraw his resolution plan. Then they say the existing framework provides no scope for effecting further modification or withdrawal of COC approved resolution plan at the discretion of resolution applicants once the plan has been submitted to NCLT. And then they say NCLT, NCLT should be sensitive to the effect of delays and be cognizant that adjournments hamper the efficacy of judicial process. So we keep on seeing dates being given at each hearings. So Supreme Court says, Honorable Court says that you should be sensitive to the timelines. They say they should endeavor on best effort basis to strictly adhere to the timelines stipulated under IBC and clear pending resolution plans forthwith. Judicial delay was one of the major reasons for failure of earlier insolvency framework. We cannot let the present insolvent regime to meet the same fate. After this order came, we would be aware that a lot of benches, posted resolution matters up in the cost list and started deciding. Unfortunately, again, the situation has reverted back and we are again facing delays at the courts. But with improvement in infrastructure and vacancies getting filled up, maybe we'll see some improvement in the outcome of cases as well. So that's it from my side on the cases. Any questions? Anything you want to discuss about? I took 7 minutes more. I'm sorry about that. Madhusudan Rao Garu, you want to ask something? You're on mute, sir. Yes, sir. You are saying something, sir.
No, I'm saying not related to this doubt, some other doubts.
Anything, sir.
Okay.
IBC is one
Sir,
area.
Then I have one small doubt, sir. In one of the case, the applicant claim has not been adjudicated by any court. But one high court has given one odd. The problem is the claim has not been acknowledged by the corporate debtor, or invoices has not been acknowledged by the corporate debtor. On that point, they went to high court.
Okay.
High court says, so you first pay the 10 lakh rupees and appoint the mediation.
Arbitrator.
They paid the 10 lakh rupees and appointed the mediation.
Okay.
Now my problem is, unless, but the case is pending since more than 15 years in a high court, due to whatever reasons. Now my problem is, regulations are saying acknowledgement of debt hona chahiye, or invoices clearly acknowledged as a service received hona chahiye, or court has given decree stating that this much amount has to pay.
Right.
So can I accept their claim or reject? I am rejecting. They are again and again is saying when court is ordered 10 lakh rupees payment ke liye, it is deemed that my case is admitted karke. My claim is should be admitted karke.
No, court's acceptance to pay is only to initiate mediation proceedings. When you have to appoint an arbitrator, you have to deposit some amount of money. Even when you challenge an arbitration petition, you have to deposit at least 50% of the amount pending. That doesn't mean the case goes in their favor.
Yes, sir. Yes, sir. Yes.
Correct. So if you don't have substantiative documents,
yes, sir,
you can always keep it under verification in the claim list.
Okay. Adjudication under claim. Okay, claims under adjudication.
Under verification, adjudication, you can keep it there.
Okay, sir.
Right?
Okay,
I think that will be the better option.
Yes, sir. Yes, sir. Yes, sir. Yes, sir.
Let
Thank
them
you
go to
for
NCLT, sir. You let them.
yes, sir. We are saying you go to NCLT, but officially I can't write you go to NCLT karke. We are rejecting. When we are rejecting, they have to go to NCLT.
Simply send them an email saying that since the company has never acknowledged the debts, it's a disputed debt, right? And you are not able to substantiate that it should be accepted. That's why we are keeping it under verification, and it will be pending adjudication by appropriate forum.
Okay, sir. Okay. Yes, sir. Thank you, sir.
No problems. Anybody else? Anything?
Thank you so much, sir, for helping the understand the Supreme Court cases in detail. It was very informative. Thank you so much for the session. And thank you to all the participants also.
Thank you.